Hello guys, thanks for coming back to Law Troop. You all are welcome to join in this discussion on section 9 of the Code of Civil Procedure 1908, CPC in short. PDF is linked below for you to download. Let us begin. If you look at the index of CPC, you will see that it is divided into various sections and orders. These sections are further divided into 11 parts, and sections 9, 10 and 11 come under part 1, which is suits in general. So this part is dealing with the principles governing suits in general, like while filing any suit, what points you should keep in mind. Sections 9, 10 and 11, which we are going to discuss in the current and in the upcoming videos, deal with the jurisdiction of the civil courts and the principle of res judicata, which are very important subjects both for the purpose of exams and as well as in practice. Let us first see section 9. Section 9 of CPC is all about the jurisdiction of the civil court to entertain a suit or a case. We will first discuss what do I mean when I say jurisdiction of a civil court, or for that matter what is meant by the term jurisdiction in general, which can be of any court. Jurisdiction is basically the power of the court to entertain a particular cause. I will give you a very general example. If you ask your history teacher to check your English notebook, so she would say, I'm sorry, it is not the subject I teach and I do not have the power to check this notebook. Basically, that subject is not within her jurisdiction and she won't entertain it. Similarly, not all the courts have the power to entertain or to try civil suits. Courts work within a defined area. Therefore, only civil courts can entertain civil cases, or vice versa, that civil courts will only try civil matters. In simple words, jurisdiction is whether or not the court can hear and decide your case. There are mainly 4 kinds of jurisdiction. First is over the subject matter. Like in section 9 CPC, we will see that civil courts can try suits of civil nature only. So if you go to a civil court asking for bail, then it will not give you any relief, as bail matters come under criminal proceedings and are not civil in nature. What can be considered to be civil matters? Let's see. Suits for injunction, partition, probate, etc. are civil in nature and will be tried by civil courts. Now there are further divisions amongst civil courts as well, like court of a civil judge, district judge, family judge, etc. and they hear cases according to their respective powers under various acts. The second kind of jurisdiction is territorial or area-wise jurisdiction. Section 16 read with section 20 determines territorial jurisdiction of immovable properties and in other cases, which we will discuss in detail in another video. But as of now, keep in mind that you cannot go and file a suit at any place you want to. For example, if in a partition suit property is situated at Southwest District of Delhi, then case will be filed in a court in Delhi under which Southwest District comes. It cannot be filed in a court with jurisdiction over North Delhi or in some other state as per the convenience of the party filing the suit. Now third is pecuniary or monetary jurisdiction, which is that case involving certain value of property or money will be entertained by different courts. For example, in Delhi, where the value of suit property is higher than 2 crore rupees, it will be filed in the High Court only and not in the District Court. Section 15 of CPC says that the suit should be filed in the court of the lowest grade, basically referring to the pecuniary jurisdiction of the civil court. So where value is lower than 2 crore rupees, it will be filed in the District Court, not in the High Court, where it might go on later in the form of appeal. Now fourth is original or appellate jurisdiction. What is the difference between these two? Under original jurisdiction, court entertains original suits, and under appellate jurisdiction, they entertain appeals. What is an original suit? It is the first suit you file in the court as against an appeal. You can say the first step you take when you file a case. Whereas what happens under appeal is that you have to come from courts below. When they did not decide the case in your favor, then you filed an appeal. Appeal is not the first step. The court where you had filed the plaint or your suit the very first time, that court you approached the first time, the court that heard your matter afresh, that court was exercising its original jurisdiction. Let us again look at the above example. So I have told you that wherein value of suit property is higher than 2 crore rupees, it will be filed in the High Court and not in the District Court. So if the value of property in Delhi is more than 2 crores, the High Court will exercise its original jurisdiction, because that is where the case will go directly. This District Court will have no jurisdiction with regard to such property. However, if the property has value of say rupees 1 lakh, then case will be filed in the district court afresh, which will exercise its original jurisdiction. Thereafter, if party against whom the case is decided files an appeal in the higher court, then that court will be exercising its appellate jurisdiction. So all these four jurisdictions are to be taken care of while filing a court case. Now we will look at the wordings of section 9, which deals with the jurisdiction of civil courts in India. A civil court has the jurisdiction to try a suit of civil nature. The word civil has not been defined in the code, but it means relating to private rights and remedies of parties involved, as distinguished from other rights like political rights or criminal proceedings. Let us discuss in detail what is suit of a civil nature. A civil suit is filed for the enforcement of private or civil rights, basically rights and remedies of the individuals considered as private persons, in contrast to public rights, criminal proceedings, political rights, or rights against the government. A suit is of a civil nature if the principal question therein relates to the determination of a civil right and enforcement thereof. Therefore, it is the subject matter of the case, or what is the dispute about, which determines whether or not the suit is of a civil nature. A suit in which the principal question relates to caste or religion is not a suit of a civil nature. But as per explanation 1 of section 9, if the principal question in a suit is of a civil nature, the right to property or to an office, and the adjudication incidentally involves determination of relating caste question or religious rites and ceremonies, it does not cease to be a suit of a civil nature, and the jurisdiction of a civil court is not barred in that case. Basically, it means that where the main dispute is civil in nature, then the incidental issues in the same suit, even if not civil in nature, can still be decided by a civil court. The court has the jurisdiction to adjudicate or to decide upon those questions also, in order to decide the principal question, which is of a civil nature. Explanation 2 of section 9 provides that a suit relating to a religious office is maintainable whether or not it carries any fees, or whether or not it is attached to a particular place. Suits which are of civil nature and those which are not are included in the PDF linked below. Some examples of a civil suit are suits relating to rights of worship, suits for restitution of conjugal rights, suits for dissolution of marriages, suits for rent, suits for rights to hereditary offices. So as per section 9, the civil court will hear and decide all such cases of civil nature unless it is expressly or impliedly barred to do so. Now we will see what is expressly and what is impliedly barred. Expressly barred means it is written in an act that the jurisdiction of cases falling under such an act won't be tried by civil courts. Impliedly means it is not mentioned in the act, but you can draw an inference or take a hint, like either special tribunals are set up or some other existing authorities are given exclusive powers to deal in such cases. But if the special tribunal has limited jurisdiction and it cannot decide all the issues in a given case, then the jurisdiction of a civil court is not barred. Presumption should be made in the favor of the jurisdiction of a civil court. A civil court has inherent powers to decide its own jurisdiction, which basically means that when you file a suit before a court, it can itself decide whether or not it has the jurisdiction to proceed with that suit, even if eventually the court comes to the conclusion that it has no jurisdiction to try that suit. Another point is that consent between the parties can neither confer nor take away the jurisdiction of a court. However, if there can be more than one court with the jurisdiction to decide a dispute in future, then parties can in their contract add a clause as to which of those courts is to be taken recourse to in case of a dispute between the parties. Okay, another point to note is that a decree passed by a court without jurisdiction is a nullity and can be challenged at any stage. Section 21 of the Code of Civil Procedure talks about the stage when you can challenge the jurisdiction of the court. Another point is that jurisdiction is to be determined through the averments made in the plaint and not upon the defense in a written statement, which means that the court will see the contents of the plaint and not that of the written statement filed by the defendant to determine the jurisdiction. Burden of proof with respect to jurisdiction of a court is on the party who asserts that the court has no jurisdiction. Now, in the end of the video, if you look at the opening words of section 9 CPC, it throws in every case which is not barred within the jurisdiction of civil courts. The logic for such wide doors or such a wide spectrum is that in a civil society, if there is a right, there should be a mechanism to enforce it. So wherever that mechanism is not exclusively mentioned or given, the civil code becomes the machinery for enforcement of such rights. Because what will the right do if there is no place you can go to when it is violated? This is it for today's video, guys. Thanks for watching it. I hope that you have understood section 9 of the CPC thoroughly. In case of any query, please feel free to comment below, like, share, and also do not forget to subscribe to the channel for more such videos.